Welcome to the Mondoweiss podcast. I'm your host, Dave Reed. At Mondoweiss, we cover the movements, activists, and policymakers who affect the struggle for freedom in Palestine. Last month, a U.S. Court of Appeals upheld an Arkansas law that prohibits state contractors from boycotting Israel. The 9-1 decision reversed a previous ruling that determined the law was unconstitutional. Despite the fact that over 30 states have adopted similar laws, it was the first full federal appeals court ruling on the subject. The decision was written by Judge Jonathan Kobes, a Trump appointee the American Bar Association rated as unqualified when he was nominated. The Arkansas story dates back to 2018, when a local paper, the Arkansas Times, refused to sign a pledge promising to refrain from boycotting Israel in order to obtain an advertising contract with a public university. The paper's publisher, Leveritt, sued the state over the law and was represented by the ACLU. Leveritt has said he's not a supporter of the BDS movement, but launched the complaint over First Amendment concerns. Our U.S. correspondent Michael Aria spoke with Amal Thabata, the Michael Ratner Justice Fellow at Palestine Legal, about the ruling and its potential legal impact going forward.
Yeah, this story kind of begins in 2018 when the Arkansas Times sued the state over its anti-BDS law. I think a lot of listeners probably know the details in the case, but for people who might not be familiar, can you just briefly explain what that Arkansas law entailed and why the paper launched the lawsuit?
Yeah, absolutely. And I think it's helpful to give some context into anti-BDS laws a little bit more generally. So, since 2014, anti-boycott legislation targeting the movement for Palestinian rights has been introduced in federal and state and local legislators and even adopted by executive order. This type of legislation generally attempts to use economic coercion to suppress boycotts, primarily through prohibitions on state contracts and state investment in individuals and entities that boycott in support of Palestinian rights. And this is what the Arkansas anti-boycott law is all about. This state law forces entities and individuals who are doing business with the state to sign a contract or a pledge stating that they will not boycott Israel or territories controlled by Israel. The law also calls for the creation of a blacklist of companies that boycott Israel, and even requires public retirement systems to divest from these companies. So in late 2018, in December, the American Civil Liberties Union filed a lawsuit challenging this Arkansas anti-BDS law on behalf of the Arkansas Times, a local newspaper. And newspaperman and publisher of the Times, Leveritt, not only refused to sign the pledge, but he also sued the state. The paper doesn't take a stance on the boycott, and Leveritt himself even expressed that he doesn't support it. But he didn't believe that the state should have the right to tell his paper or any other business whether it could participate in a political movement. So the paper lost a lot of ad revenue when its biggest advertiser, State College in Arkansas, said that it would no longer advertise unless the Times took the pledge that it wouldn't boycott Israel. And, the publisher Leveritt was, stated he was really surprised when he received an ultimatum from the university, a longtime advertiser, when they said, to continue receiving its ad dollars, they would have to certify in writing that their company was not engaged in a boycott of Israel. He described it to be, really puzzling. He says that although boycotting Israel couldn't have been further from their minds, and though state funding is a significant source of their income, their answer was no, because they don't take political positions in return for advertising. He believed that if he signed the pledge, they'd be signing away their right to freedom of conscience. And as journalists, they would be, quote, unworthy of the protections granted to them under the First Amendment. So in January 2019, the district court dismissed the case. And almost a year later, the Eighth Circuit Court of Appeals reversed that decision, finding the law unconstitutional. And this decision was monumental. It was the first time a federal appeals court had decided on the constitutionality of anti-boycott laws. However, unfortunately, in response, the state moved for a larger panel of judges to rehear the case. And just this past month, in June 2022, the Eighth Circuit upheld the Arkansas law, finding it constitutional. And that's where we currently stand today.
I wanted to talk about this specific ruling, which was written by this judge, Jonathan Kobes, who was a conservative. He was appointed by Donald Trump. In his decision, he wrote that the law, quote, only prohibits economic decisions that discriminate against Israel. Because those commercial decisions are invisible to observers and less explained, they are not inherently expressive and do not implicate the First Amendment, end quote. I'm wondering what you make of that interpretation from a legal perspective. We've seen a lot of these laws fall apart when they hit the courts. And even, I think we've seen these anti-BDS laws, they've kind of became recalibrated a little after they were challenged. And now you see, you see them written in a way where it has to be a certain amount of employees. It has, the company has to make over $100,000. So I'm just wondering what you make of this decision in the context of the precedent and the history we've already seen. Does this strike you as a departure? And what do you think? Do you think this potentially opens up floodgates for similar decisions and rulings when in terms of challenging these laws?
This is all happening in the context of the broader, coordinated and well-financed efforts by Israel-aligned groups to stifle a viewpoint in favor of Palestinian rights, as well as the long history of the tactic of boycotts to advocate for social change and the importance of the role of the courts in protecting First Amendment rights. So when the Eighth Circuit issued its ruling upholding the district court's original decision, the full court refused to recognize the free speech components of the case. Claiming, like you mentioned, that economic and commercial decisions are invisible and not inherently expressive conduct, and that therefore the law was not in violation of First Amendment speech rights. So under the court's interpretation of Claiborne, the Constitution would only protect entities that are advocating for a boycott, but not actually engaging in a boycott. So taking the facts of Claiborne under this reading, the NAACP would be allowed to advocate for the boycott of white establishments to challenge a political system that denied Black people basic rights without being punished. But actually engaging in a boycott would be punishable. So does this decision feel like a departure from existing precedent? To me, it absolutely does. The court's decision departs from long-standing traditions. It ignores the fact that this country was founded on a boycott of British goods and that boycotts have been a fundamental part of American political discourse ever since. This ruling, truly does ignore that history and precedent, treating the state law as a restriction on purely commercial conduct that carries no political message. And this decision is an attack on our right to dissent from the status quo. In upholding the Arkansas anti-BDS law, the court refused to confront the reality that these laws are part of an effort to shield Israel from accountability. And, given the proliferation of anti-boycott laws targeting other social justice movements, this decision also really sets a dangerous precedent for anyone interested in seeking social or political or economic change. For example, the reasoning used by the Eighth Circuit could be used to justify laws that prohibit the state from contracting with companies that boycott fossil fuel companies, for example, laws that Kentucky, Oklahoma, and Texas recently passed. So we know that these bills, these anti-BDS bills, are meant to target and punish advocacy for Palestinian freedom, but the court's ruling makes it easier for states to target any type of activism that they don't like under the guise of economic well-being. And this decision, yet again underscores that our legal system is not a safety net. The law, Constitution, and Supreme Court have all been used at times to uphold discriminatory and violent policies. And advocacy for Palestinian rights exposes parts of the cracks in the country's foundation, where rights like that to free speech don't apply to those who challenge the injustices of the US or its allies. And that's why it's so important, in my opinion, to continue to raise awareness and to organize, because we're seeing that with each new wave of Israeli violence, there's further awareness, sympathy, and organizing for Palestinian rights. The movement won't let rulings like these stop them. History shows us that bad decisions by courts can't stop a principled justice movement. So even as these battles play out in courtrooms and capitals, the critical work of organizing continues towards our ultimate goal, which is freedom and justice in Palestine and the US and beyond.
I realize this situation is very fluid. It's hard to predict, obviously, what happens next. The ACLU, who represented the paper, has said that they're looking into next steps. At least last time I checked, they hadn't appealed yet. But do you have any indication of what might come next with this particular fight? And if there is an appeal, is this a case that could potentially make its way to the Supreme Court?
Yeah, I absolutely see this ruling impacting future rulings on anti-BDS laws. Like I mentioned, this ruling was just wrong on precedent and history. And I think it'll have serious implications for everyone's free speech rights. And I think as of yesterday, the ACLU confirmed its plans to appeal to the Supreme Court. That being said, we're not under any illusions that the Supreme Court will act to protect fundamental rights. There is some hope that they will have some sympathy for free speech rights. I think that this uncertainty underscores the critical need for organizing, like I mentioned, going beyond legal challenges to build the political will to repeal these problematic laws. And, as always, continuing to advocate for Palestinian rights, including via boycott campaigns, targeting entities that are complicit in Israel's violations of Palestinian rights. So I think a Supreme Court ruling overturning or narrowing Claiborne could have a significant impact on First Amendment rights more broadly, and not only in terms of chilling Palestinian rights advocacy, but other movements as well. It's important to note that these anti-BDS laws are targeting such a small subset of activism and focus primarily on state investments and contracts. So, even if these laws are found to be enforceable as written, there's still a right to boycott. And, BDS is still happening in a lot of different ways that are outside the scope of these laws.
I was wondering if you could talk maybe a little bit about the kind of ironic political context that we see these battles occurring in currently. Since the invasion of Ukraine, we've seen all kinds of calls across the political spectrum from political organizations, calls to, boycott and sanction Russia over the action. I read an article the other day that orchestras were, some orchestras were not playing the 1812 overture during July 4th fireworks celebrations because the song was originally written to celebrate Russia defeating Napoleon. So some of these calls are really pretty ridiculous, and they're happening, while these anti-BDS laws are being pushed. Can you talk a little bit about the cultural disconnect there? We're seeing all these calls while states are pushing and upholding laws that are trying to literally make it a crime to boycott Israel. What do you make of that disconnect?
First and foremost, this example with Russia and boycotts demonstrates how boycotts are such a natural response to perceived injustice, and historically such a powerful tool for seeking justice. I also think that the distinctions on how BDS is targeted are important to highlight as well. While the Arkansas decision failed to recognize boycotts as a powerful tool for people to express their views and play a personal role in issues playing out on the global stage, the recent trend of boycotting Russia, while at times misguided, reflects how ingrained the concepts of boycotts are in our society. Unlike these blanket bans on anything perceived to be Russia, BDS is a thoughtful, targeted, and strategic response to entities that are actually complicit in Israel's unfair treatment of Palestinians. I think it's also important to, draw out the distinction of the fact that calls to boycott Russian products or individuals are often coming from powerful politicians who have already used their authority to implement governmental sanctions against Russia. So in contrast with BDS, which is trying to use people power to collectively amplify grassroots calls for justice, the boycotts of Russia are a top-down approach that, in a sense, mirrors the anti-boycott laws themselves, since we also saw a widespread effort from states across the country to boycott and divest from Ben & Jerry's when they decided to stop doing business in illegal Israeli settlements on Palestinian land. But all of this being said, I think that there is, certainly a double standard whenever it comes to Palestine. but an increasing amount of people are seeing Palestine as central to racial justice struggles. And these examples of Russia boycotts really show that Palestine should not be the exception.
And finally, and you already alluded to this a little in one of your previous answers, these laws are obviously dangerous and disturbing on their own terms. But, we're already seeing how this logic can be expanded to any form of boycott. And in fact, already has in some parts of the country. I think with some of these states, they don't even have an economic relationship with Israel. It's obviously just kind of like a right-wing symbolic piece of legislation. Maybe there's people who don't take it, very seriously because it doesn't necessarily apply to a lot of people. But can you talk about the wider dangers of anti-BDS laws and how they open up kind of a Pandora's box when we talk about, wider crackdowns on activism?
Absolutely. I think like exactly like you just mentioned, while these bills, if enacted, chill free speech, by effectively dictating that a position supporting human rights is unacceptable, they also intimidate individuals and businesses from adopting ethical political stances regarding Palestine and Israel, because these individuals know that their decisions based on human rights concerns could result in a denial of a contract with the state. And although these bills typically apply only to public contracts, if enacted, they likely will chill other expressive activity. For example, similar laws have been invoked in order to chill student and community activism in support of Palestinian human rights. They've also been invoked to prevent public talks at universities, to censor school teachers, which we've seen a lot, and to cancel cultural events. So even where these censorship efforts have failed, confusion over the scope or even deliberate misapplication of these anti-boycott laws did in fact chill or punish or attempt to punish speakers supporting Palestinian rights. And in fact, anti-boycott laws have tangible consequences beyond the direct effects of denying contracts and compelling speech. Musicians, teachers, students, professors, and grassroots activists have reported ways that anti-boycott laws have been used to threaten careers, homes, and educations. So the impact of legislation targeting Israel boycotts goes far beyond chilling advocacy for Palestinian rights. And we've seen that, anti-Israel boycott laws have become a model for other types of anti-boycott legislation, targeting protests in support of other social justice issues. A dozen of states have introduced or passed anti-boycott legislation, for example, targeting efforts to address climate change or even gun violence. So given the proliferation of anti-boycott laws targeting other social justice movements, again, I think this decision specifically sets a really dangerous precedent for anyone that's interested in seeking social, political, or economic change.
Well, thanks so much for chatting with us.
Yeah, absolutely. Thank you so much for having me.
Thanks for listening to our show, a production of mondoweiss.net. The music is from Sound of Picture. Visit our site to sign up for free daily and weekly newsletters on Palestine, Israel, and related U.S. politics. If you're enjoying our podcast, please consider becoming a donor by visiting mondoweiss.net/donate. Mondoweiss is a nonprofit publication, and every donation of any amount helps sustain our work. Don't forget to subscribe to this podcast wherever you listen, and please leave a rating and review to help other listeners find our show.